distribution of pay and in the media's application in these appeals.
Lord Rodger will give the judgment of the court in relation to anonymity.
The substantive appeals relating to freezing orders under terrorism legislation involve 5 individuals. 4 of them, A, K, M, and G, are appellants. The 5th, HAY, is the respondent and cross-appellant in an appeal by the Treasury. When the appeals were lodged before the Supreme Court, the individuals' names were concealed by the use of letters. This was the result of anonymity orders first made at the outset of the proceedings in the Administrative Court, and in the case of A, K, M, and G, then continued by the Court of Appeal. At the start of the hearing of the appeals, Guardian News and Media Limited and other members of the press made an application to have the anonymity orders recalled. The application was opposed by the individuals concerned. At that initial stage, the Supreme Court decided to recall the order in the case of G, as the court was shown material confirming that his identity as a person subject to a freezing order was already in the public domain. He was subsequently named as Mr. Mohammed al-Ghabra. The court postponed consideration of the application relating to AKM and HAY until after the substantive hearing of the appeal. The court now grants the application by the press in respect of these individuals. In disposing of the opposed application, the court was being asked, on the one hand, to give effect to the right of the press to freedom of expression under Article 10 of the European Convention on Human Rights, and, on the other, to ensure that the press respect the 5 individuals' private and family lives under Article 8 of the Convention. The court has had to weigh these competing claims. Having considered the circumstances relating to each of the individuals, for the detailed reasons set out in the court's judgment, the court has unanimously concluded that the Article 10 rights of the press should prevail to the extent of permitting them to report the individuals' names. The court accordingly orders that A, K, M, and HAY should be named as Mr. Mohammed Jabar Ahmed, Mr. Mohammed Azmir Khan, Mr. Michael Martin, formerly known as Mohammed Tanvir Ahmed, and Mr. Hani al-Syed Sabaei Youssef, or Hani al-Sabaei, respectively.
Lord Hope will now give the judgment in the substantive appeal.
In response to various incidents of international terrorism, including the attacks on 9/11, the United Nations Security Council passed resolutions requiring member states to freeze the assets of Osama bin Laden, the Taliban and their associates, and those involved in international terrorism. It also established a list of persons whose assets member states were obliged to freeze. Those named on that list were not informed of the basis for their inclusion or afforded the right to challenge the decision before an independent and impartial judge. In contrast to other countries, such as New Zealand and Australia, which gave long-term effect to these resolutions by acts of Parliament that were subject to the oversight and scrutiny of the legislature, the government of the United Kingdom took action to implement them by orders made by the executive. The Terrorism United Nations Measures Order 2006 and the Al-Qaida and Taliban United Nations Measures Order 2006 were made by Her Majesty's Treasury. They were not subject to review or approval by Parliament. These appeals all concern persons whose assets have been frozen automatically by being designated under one or other or both of these orders. A number of features of these orders must be noted. First, the system of asset freezing has a very severe effect on the ability of designated persons to access or use their property or obtain funds of any description from any source. Their freedom of movement, their liberty, and their private and family lives are all gravely restricted, as are those of their families and others they come into contact with. Yet it is not subject to any form of judicial review, and once a person has been designated, the restrictions last indefinitely. Secondly, the orders allow the Treasury to freeze assets of a person whom it reasonably suspects is involved in terrorism. This goes beyond the words used by the UN Security Council in its resolutions describing the obligations imposed on the member states. Thirdly, those persons who are listed at UN level are named as terrorists and deprived of access to their assets without any right to challenge the validity of the measures taken against them. They're deprived of their right of access to a court. The orders were made under Section 1 of the United Nations Act 1946, which gives the Treasury the power to make orders that are necessary or expedient to give effect to Security Council resolutions. The issue in these appeals is whether, in enacting that section, Parliament intended to give the Treasury power to make orders that interfere so profoundly with an individual's fundamental rights without parliamentary scrutiny. The Court has held that Parliament did not so intend, and that in making these orders, the Treasury exceeded the powers conferred on it by that section. It decides unanimously that the terrorism order must be quashed, and by a majority of 6-1, Lord Brown dissenting, that Article 3.1b of the Al-Qaida order must be quashed also. If the Executive considers that such far-reaching measures are necessary or expedient for combating terrorism or honouring the United Nations international obligations, it must obtain approval for them from Parliament. It is important to emphasise that in quashing these orders, the Court is not interfering with the will of Parliament. On the contrary, the Court's judgment is based upon the fundamental principle that it is for Parliament and not the Executive to determine whether and to what extent the individual's basic rights may be restricted.